A federal court has just declared Donald Trump's tariffs to be illegal. An injunction has just issued blocking Donald Trump's ability to impose these tariffs against the world that he did on what he called Liberation Day, which I call Great Recession or Liquidation Day. Donald Trump purported to invoke powers under the International Emergency Economic Powers Act of 1977, alleging that there was this national emergency to take these, in essence, dictatorial powers to impose these tariffs on every single country. But this federal court just struck it down and said, Donald Trump, you are not allowed to do that. You are permanently enjoined, blocked from issuing your tariffs. A massive blow to Donald Trump. I want to go through this order with you as only we do here on the Midas Touch Network. Not just give you the headline, but really break it down. Which court issued it? What was their analysis? How did they break down what the actual powers are of a president to impose tariff versus the requirement that Congress be the actual body that legislate in this area? Why was Donald Trump violating the law? So let's break it all down. So what was the name of the federal court that issued this order? It's called the United States Court of International Trade. They actually have exclusive jurisdiction over issues regarding, you guessed it, international trade. Interestingly, it is a 3-judge panel, and all 3 of these federal judges all agreed in what's called a per curiam opinion, which means they basically all agreed. They didn't even have to necessarily even sign it, saying that we all agree clearly Donald Trump does not have this power. So let's go through the order and let me explain to you what these judges held. This is disastrous news for Donald Trump and good news for the United States Constitution. So here's the order. The Constitution assigns Congress the exclusive powers to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. And it cites the United States Constitution, Article 1, Section 8, Clauses 1 and 3. The question in the 2 cases before this court is whether the International Emergency Economic Powers Act of 1977, the IEEPA, delegates these powers to the president in the form of authority to impose unlimited tariffs on goods from nearly every country in the world. The court does not read the IEEPA to confer such unbounded authority and sets aside the challenge tariffs imposed thereunder. Now, who was the individual or organizations that filed this? Well, you had a company called VOS Selections, Inc., Plastic Services and Products, Inc., and then this was also joined, because this was a combined case, by states like the state of Oregon, Arizona, the state of Colorado, Connecticut, Delaware, and others. This was a consolidated case of companies that were impacted and harmed, and also by states that were impacted and harmed, and the court found there was standing to sue. So after citing the Constitution, the court gives a little bit more detail, and it says the following, and this is what's important that you all know, what our Constitution says, because we have a Constitution in the United States, and this is what we've always been saying on the Midas Touch Network. Just because Donald Trump claims these powers, it doesn't mean he has them. Here's what the Constitution says. While Congress may not transfer to another branch powers which are strictly and exclusively legislative, Congress may confer substantial discretion to implement and enforce the laws. Thus, courts have consistently upheld statutory delegations as long as Congress lays down by legislative act an intelligible principle to which the person or body authorized to exercise the authority is directed to conform. This reflects the idea that in modern government, the legislative process would be bogged down if Congress were constitutionally required to appraise beforehand the myriad of situations to which it wishes a particular policy to be applied and to formulate specific rules for each situation. Then it goes into tariffs. Early in the nation's history, tariffs were a key means by which the federal government raised money to pay wages and to fund the national debt. And it goes on to say the revenue-raising purpose of tariffs has declined significantly since the ratification of the 16th Amendment in 1913, permitting the imposition of income taxes, 1913. Since then, and with the increasing complexity and interconnectedness of the global economic landscape, tariffs have served more diverse purposes, including restricting the importation of certain goods, protecting American industry, and leveraging negotiations with foreign counterparts. As global economic relations grew in volume and complexity, Congress saw a need for specialized, nonpartisan assistance in administering tariffs. Congress accordingly passed legislation creating the United States Tariff Commission, later renamed the United States International Trade Commission. To provide this assistance, the Commission shall have the power to investigate the tariff relations between the United States and foreign countries, commercial treaties, the volume of importations compared with domestic production, and consumption and conditions, causes, and effects relating to competition of foreign industries with those of the United States. The ITC is responsible for maintaining the United States harmonized tariff schedule, the HTSUS, which sets tariff rates for all merchandise imported into the United States. The HTSUS itself is indeed a statute, but is not published physically in the United States Code. Congress's enactment of the HTSUS provided that its term shall be considered to be statutory provisions of law for all purposes. Then it says, in addition to forming the ITC, Congress has responded to the growing complexity of global economic relations by delegating trade authority to the president. These delegations have included clear limitations that retain legislative power over the imposition of these types of duties. And then it says, however, there's certain emergency authority. And then it talks about one such emergency authority that in 1974, the United States Customs Court, the predecessor to the United States Court of International Trade, heard a challenge to President Nixon's imposition of a supplemental duty on all dutiable merchandise imported into the United States. The U.S. Customs Court construed this law so as to preserve constitutionality and held that the TWEA precludes the president from laying the supplemental duties provided in this case by President Nixon. And it went on to say how this IEEPA was ultimately created. And it says, shortly after this decision, and following a review by a Senate bipartisan special committee, Congress reformed the president's emergency powers. As part of this reform, Congress cabined the president's powers under the TWA to wartime. TWA is amended by striking out or doing other period of national emergency declared by the president in the text preceding subparagraph A. Congress also enacted a new statute, the IEEPA, to confer upon the president a new set of authorities for use in times of a national emergency, which are both more limited in scope than those of this TWA and subject to more procedural limits. And it goes on to cite, what is the IEEPA? It provides that the president may investigate, regulate, or prohibit any transaction in foreign exchange, transfers of credit payments between by and through, or to any bank institution to the extent that such transfer of payments involve any interest of any foreign country or national thereof, the importing or exporting of currency or securities by any person or with respect to any property subject to the jurisdiction of the United States. B, investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of or dealing in or exercising any right, power, or privilege with respect to or transaction involving any property in which any foreign country or national thereof has any interest by any person or with respect to any property subject to the jurisdiction of the United States. The IEEPA further provides that those authorities may only be exercised to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared for purposes of this chapter and may not be exercised for any other purpose. So then it explains how Donald Trump then expanded this idea of a national emergency to basically include everything that was going on with the world in Europe, in Canada, in China, and elsewhere. And Trump said, we have a national emergency with every single country. And the federal court said, no, you don't. Underlying the issues in this case is the notion that powers properly belonging to one of the departments ought not to be directly and completely administered by either of the other departments. Because of the Constitution's express allocation of tariff power to Congress, we do not read the IEEPA to delegate an unbounded tariff authority to the president. We instead read the IEEPA's provision to impose meaningful limits on any such authority it confers. Two are relevant here. First, Section 1702's delegation of a power to regulate importation, read in light of its legislative history and Congress's enactment of a more narrow, non-emergency legislation, at the very least does not authorize the president to impose unbounded tariffs. The worldwide and retaliatory tariffs lack any identifiable limits and thus fall outside the scope of Section 1702. And second, the IEEPA's limited authorities may be exercised only to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared, and may not be exercised for any other purpose. As to these tariffs, they do not meet that condition, and they fall outside of its scope. Let's just go to the conclusion right here. The court holds for the foregoing reasons the IEEPA does not authorize any of the worldwide retaliatory tariffs. The worldwide tariffs exceed any authority granted to Trump by the IEEPA to regulate importation by means of tariffs. The tariffs fail because they do not deal with the threats set forth in those orders. This conclusion entitles the plaintiffs to judgment as a matter of law, as the court further finds no genuine dispute as to any material fact. Summary judgment will enter against the United States. The challenged tariff orders will be vacated and their operation permanently enjoined, meaning their operation is over, it's stopped, it's done. Trump is not allowed to tariff the way he did. Unlawful, against the whole world, immediately done. Now, Donald Trump is going to appeal this right away, but this is a massive blow to Donald Trump. I can't emphasize enough how big this order is right here, blocking Donald Trump from implementing his tariffs under the IEEPA. The United States Court of International Trade, the three-judge panel, unanimously has so concluded, a massive blow to Donald Trump. We'll keep you posted with more here on the Midas Touch Network. Hit subscribe. Let's get to 5 million subscribers. Can't get enough Midas? Check out the Midas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MidasPlus.com.